Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of O'Keefe versus Snyder. This case was heard in the New Jersey Supreme Court in the year of 1980. Let's go ahead and jump into the facts of the case. Plaintiff in this case, Georgia O'Keefe, a very famous painter, had a few paintings on display at an art gallery in the 1940s. The art gallery was owned by her late husband, Dr. Stieglitz, and while they were there, she claimed that they went missing. She couldn't find this artwork for a while. Ultimately, about 25 years later, she's wandering around in an art gallery and she sees this art and she's like, oh my goodness, these are my paintings that were stolen forever ago. I want them back. So she files a claim against the defendant, Snyder in this case, the owner of the paintings, and issues a action for replevin. Replevin means you're just reclaiming your stolen goods. So that's the issue of the case. That's what gives rise to the dispute. Snyder says, hey, I own these paintings. These aren't yours. Snyder had purchased the paintings from a gentleman with the last name of Frank. And Frank said that he got the paintings from his parents. And he says that his parents actually bought these paintings from Dr. Stieglitz. So the facts are not aligning very well. And so ultimately the court says, hey, we need to take this back to a plenary hearing. We got to get these facts straight so we can answer what's going on in this case and how we're going to figure this out. The court doesn't just toss it aside at that point, though. It still decides, hey, we're going to answer the question of the law. Even though we don't have the facts yet, we're going to answer the question of the law so that when it's at the lower court, they don't have to, go ahead and try and appeal this back up to us. They can just put this to rest because we'll already have the law straightened out. The trial court, before it was appealed to the New Jersey Supreme Court, the trial court ruled in favor of Snyder, saying that the statute of limitations, 6 years is what it was for a chattel, had run, and that O'Keefe couldn't claim the painting after that. The appellate court reversed, stating that Snyder hadn't satisfied all of the categories of adverse possession. And the Supreme Court, when it's answering the question of law, enters a new rule. That's the big thing that we need to pull from this case, and it's the discovery rule. The discovery rule is a new rule in accord with adverse possession that says that a statute of limitations for adverse possession, one of those 4 prongs for adverse possession, does not begin to run unless the proper owner of that property, so Georgia O'Keefe, the original owner, has begun to not try to find that property anymore. So ultimately what they're saying is that the true owner has a responsibility to try and find that property, to advertise that it's missing, to put forth a reasonable effort to reclaim the property, and to put it like maybe in a catalog of sorts where people could see, hey, this was stolen, now I'm not going to buy this stolen good. So the discovery rule, which comes out of this, says that the owner of a property needs to make a reasonable effort to get that property back. And so long as they are making a reasonable effort to reclaim that property or to put someone on notice that it is stolen, the statute of limitations, so 6 years in this case, wouldn't begin running. So if O'Keefe had, began to try to reclaim those paintings for years, and that's what they remand to the trial court to try and figure out, she had begun to try and reasonably, hey, I got to get these paintings back. She puts people on notice. She, maybe tells the police department in the area, hey, my paintings are missing. Then that 6-year statute wouldn't have begun to run until she stopped trying to reclaim those paintings. So that's the key. Ultimately, the court doesn't decide, did O'Keefe do enough here, because they don't have the facts straight. The two parties' facts are disjointed, so they don't do that. The case finally, before the plenary hearing, the two parties settle with one another, O'Keefe and Snyder. O'Keefe gets one painting, Snyder gets another, and then the third one is auctioned off to pay for the parties' legal fees. So kind of an interesting end to it. Did end at settlement. After the court laid down that rules, maybe some attorneys feel like they didn't have as much ground to stand on. So that's the case. That's what you need to know for your case brief. Let's just go in and jump into some ex ante implications of the precedent and the discovery rule. So some states, New York primarily, has said, hey, we're going to reject this discovery rule. We don't like this discovery rule. And I think they have a decent reason in doing so. The discovery rule places the impetus upon the person who's had their property stolen from them to try and reclaim that property. That doesn't seem super fair, right? Like if I have my bike stolen from me, if I leave it at the train one day, I really need to be making constant efforts to reclaim that bike over and over again, even though I didn't do anything wrong. I just, left it there and someone cut the lock off of it. Just doesn't seem incredibly fair to the person who was wrongly affronted in the first place. So that's a critique of the discovery rule. It just puts too much burden on the person who didn't do anything wrong. The burden maybe should be placed upon the person who's, trying to claim that property for themselves, like prior adverse possession had done so. Arguing the good side of the discovery rule would be that it does protect, good buyers in good faith, like Mr. Snyder in this case, who he bought from Frank in good faith. Because if someone's not putting a reasonable effort out there to reclaim it, at a certain point in time, we have to give, deference to good faith purchasers in the future. If that person that lost their property isn't really trying to reclaim it, should we really just let that property sit in the dump, or should we let someone use it and let it provide economy, right? Like these O'Keeffe paintings in a gallery promoted the overall welfare of the gallery owner, whoever is working there. Maybe it helped restaurants in the area because people were going out to eat before they saw the painting. So, letting property be used, even if it's stolen, it's not necessarily terrible. It's probably good. We don't want that property to just go to waste. We want some economic benefits to come from it. So, two sides of the discovery rule. This is a fun case. I hope you enjoyed it. If you'd like to see more videos, go ahead and hit the subscribe button. Hope you have a great rest of your day. Bye-bye.